fine up to $1,000, order the incarceration in the county jail for up to 30 days, or both. Any alleged violations will be carefully evaluated, and the court will impose only those sanctions that are appropriate and proportional under the circumstances. Before imposing any sanction, the court will make specific findings on the record. In addition, the court may consider any remedial measures, including immediate suspension of video transmission for the hearing in which the violation occurs, with proceedings continuing on an audio-only basis, and disqualification, if necessary and narrowly tailored, of the news organization that filed the request in order for electronic media coverage of the court proceedings for that hearing from serving as pool camera operator in this matter, where such a measure is required to ensure compliance with the standing decorum order and protect the rights of the parties. Any such remedial measure would be considered only as a last resort and only to the extent necessary to address the specific violations at issue. Counsel will have an opportunity to provide input before the court makes any final determinations regarding sanctions. The court values that input and will give it careful consideration. I want to be clear that these measures are intended to preserve open and transparent courts while ensuring fairness to all parties, and the court remains fully committed to the presumption of open proceedings under the applicable rules. Rather, these measures exist to protect the constitutional rights of all parties while preserving the integrity, fairness, and orderly conduct of these proceedings. With respect to media coverage in the courtroom, the court offers the following additional guidance to assist everyone in navigating today's proceedings. The pool camera has been relocated to the rear of the courtroom. The camera operator shall not zoom in on any individual seated at counsel table. When counsel tables are filmed, the camera must remain in a wide shot that includes all individuals seated at the table. Attorneys and witnesses may be filmed individually when standing at the lectern or seated in the witness box. I would also ask counsel to be mindful that microphones are located throughout the courtroom and may pick up conversations. Counsel may wish to consider using screen protectors on laptops and taking reasonable steps, such as covering one's mouth when speaking, to avoid the inadvertent capture of private communications, whether by camera, microphone, or those present in the courtroom. Third, the court wishes to address the camera operator. At this time, Mr. Josh Demick, could you come forward to the lectern? Could you please state your name and spell it for the record?
Yes, my name is Josh Demick, Josh-Demick.
Thank you. My intention is not to cause you any embarrassment or discomfort, although it's probably not feeling that way on your end. I simply want to ensure that the expectations for today's proceedings are clear. Not to cause you any embarrassment, or what is your primary role?
My role is to cover the hearing that we have going on this afternoon.
I'm going to try something really quick. Okay.
I have read over the
Hold on.
Comfort, although it's probably not feeling that way.
That's just as bad. Jesus.
solely focus
That's what it sounds
on
like.
the individuals that will be speaking up here.
All right, you anticipated my next question, which was, have you read the December 23rd, 2025 standing decorum order, which you have, and I appreciate. And do you understand the guidelines as they relate to your responsibilities today, including the additional guidance regarding camera position at counsel table and the filming of attorneys and witnesses that I just put on the record that was not in the decorum order?
Yes, Your Honor.
All right. Do you need any additional time to review the order or to reposition the camera to ensure full compliance?
No, Your Honor.
Or do you anticipate any difficulty complying with the order or today's guidance?
No.
All right. Thank you, Mr. Dimick.
He actually talked about different penalties.
Before I let you go, as I just asked questions of the pool camera operator, Mr. Dimick, I'll turn to counsel Do you wish to weigh in on what the court has just done?
No, Your Honor, thank you.
Thank you.
Yes, thank you, Your Honor. Richard Novak for Mr. Robinson. May I speak from here?
Yes, Mr. Novak.
All right, thank you, Your Honor. We appreciate that the court, on its own accord, moved the videographer. I don't know where the still photographer is, but we continue to be concerned that any video images of Mr. Robinson during court proceedings, close-up images of Mr. Robinson during court proceedings, interfere with his right to a fair trial. I think I heard everything the court said about the videographer, but the still photographer is still seated in the same place where they were last week. And we would ask the court to order the still photographer not to take any photographs of Mr. Robinson's face or person during the hearing, in the same way that the videographer has now been ordered to be focused on the court, the witness, if somebody's testifying, counsel at the lectern, or generally the people seated at counsel, what the court referred to as counsel table. We do not want to see still images again of Mr. Robinson's face in the media with more speculation about meaning of his facial expressions or the lack thereof. And so we really appreciate what the court did on its own, sua sponte, I guess we would say. But we have the same concerns about the still photographer.
All right. And before I address that, any questions as it relates to Mr. Dimmick? I want to excuse him to go back. Standing in front of the court is no fun. And I recognize that.
I was just trying to keep him up there as long as
I
possible.
see. All right. Mr. Dimmick, thank you so much.
Thank you very much.
All right. Before I address that, I'll allow the parties to be heard before I address what Mr. Novak has brought up as it relates to the still photographer. To the state.
Your Honor,
TMZ receipt.
I think Your Honor is appropriately concerned about the video, any close-ups of Mr. Robinson. I'm not sure that a still camera presents the same concern. This is a public hearing, and I think that that it's appropriate that still photography be taken. I don't know that it raises the same concerns that Your Honor's raised with the video.
Thank you. Any other party wish to be heard?
I'll be brief, Your Honor. Michael Judd on behalf of the news media. We agree that with what the state has just said. The concerns that I understand the court trying to address involve the capture of moving lips that can be used by lip readers. We have dealt in the past with inadvertent overhearing of actual conversations. I don't think still cameras present that same issue. The idea that a participant in a public hearing, including the defendant, cannot have their image captured by a still camera because a facial expression is somehow too much to let the public see, we simply don't agree with. It is, of course, the court's prerogative to set the guidelines that it believes are appropriate to balance these interests, but it will come of no surprise to the court that the news media believes that particular measure of saying even a photograph of a defendant in a public courtroom is too much to allow without threatening fair trial rights in a way that goes beyond that balance. We think that's too far.
All right. Mr. Novak, I do have a question for you. Has there been a violation of the decorum order by the still photographer in any of these proceedings?
I am not aware of violations by the still photographer, but I am very aware, if I may, of what we believe is unfairly prejudicial media content based on the images. And video images, yes, can be embedded in electronic media, but still photographs also are still appearing, still photographs from the courtroom are still appearing in print media. and in less, what we've referred to as less formal media channels. So we are still very concerned, and I don't understand why there would be any even marginal negative access to the public to this hearing by the still photographer being in the back of the courtroom and taking photographs of the court, meaning Your Honor, of witnesses on the witness stand, if that's what the court's going to permit, of counsel. I don't have a problem with that. But we continue to have grave concerns of huge photographic lenses being focused on our client. And
Huge photographical lens.
the results of that, and I'll just make a representation to the court that while we were in court last time, Mr. Burt and I both received, literally in real time, long ranting voicemails from people who were watching the proceedings. Now, that was on video. I received another one of those calls today referring to my client's facial expressions from somebody who decided to leave a long, aggressive message on my office phone. And I'm very concerned that even still images of Mr. Robinson's visage in the courtroom are going to interfere with his right to a fair trial. And we've reached the point, because of the prior violations that have occurred and because of the nature of the media coverage, where Mr. Robinson feels like he may have to make a choice between two of his Sixth Amendment rights. And that's the right to a fair trial and the right to be present. And we want him to be able to have both of those rights and all of his rights. And the way he can exercise both his right to be present and his right to a fair trial is for the court to move the camera to where the video camera was ordered to be.
Thank you, Mr. Novak. Thank you to all parties. I appreciate your input. This is an important matter, and the court takes it very seriously. I note that there has been no violations of the December 23rd, 2025 decorum order by the still photographer. That being said, this court wishes to exercise caution and will request that the still photographer go behind the bar, to the bar being the separating lower wall, and reposition his camera at that place. I appreciate the patience of all parties as we do this. And again, this court is balancing open and transparent courts with the constitutional rights of all parties involved. All right, while that's occurring, I'll turn to the state. The court would appreciate a brief update on the status of discovery.
Your Honor, Chad Greenender for the state. To date, we have shared with the defense 100% of what we have received from law enforcement. With that said, we have been informed late last week that there is approximately, there's several terabytes of digital evidence from phones and other digital devices that the State Bureau of Investigations has in their possession. We are collecting a 20 terabyte hard drive to two of them, one for us and one for the defense. We did receive a letter, I think, this morning from the defense outlining their expectations with respect to how that would be received, original form, and more specifics as well. So we're in the process of coordinating that download onto those hard drives of the digital evidence that's been collected, and we will provide that as soon as we receive that.
Yeah, this judge is pretty tough.
Downloaded.
He's not
to
what
the
you
defense.
think he would be.
We are still working with law enforcement on the download of approximately.
But hey,
30
guys,
days.
could you guys please help support the channel? This is why we're able to do these shows, is if you guys are supporting the channel. Otherwise, I could be making a video or something like that.
And that's
So thank you.
being downloaded 24/7. So that is still in process. So we're actively working on that and looking forward to collecting that and passing that along to the defense. It will need to be shared in some sort of similar fashion, I'm sure, with respect to hard drives.
Thank you, Mr. Gernander. And does defense want to be heard?
That is correct, Your Honor. Stacey Visser on behalf of the defense. We are in communication with the state about what we believe is missing at this point, and we are anticipating a large amount of digital discovery in the next few weeks that we will need to process.
All right. Thank you.
May I supplement this conversation, Your Honor?
Briefly.
Thank you, Your Honor. We've kind of divided up discovery responsibilities, and mine is to address what I'll call non-digital forensics. So there are many items of seized evidence that have been sent to various law enforcement labs around the country without getting into the details.
Kind of have a
We
video
have
I need to
some
work- I need to
very,
put a video out on that.
what I'll
I
refer
can't
to
do
as
it
summary
live.
reports of those evaluations. But as the state attorneys know, we're going to need all of the underlying data, notes. These relate to things like DNA and other forensics. So if we haven't provided them with a very, very detailed list of the types of documents we need, we will. But I think, and Mr. Gernander could speak to this in more detail in terms of the status of that, but I think that's another big chunk of materials that presumably the state attorney's office has not received yet from law enforcement. And so obviously they haven't had a chance to give it to us, and we haven't had an opportunity to look at it or to have our own experts review those types of materials.
Thank you, Mr. Novak. All right, before the, Mr. Gernander.
We'll make a point to follow up on that with the law enforcement agencies. We'll communicate with defense counsel on that, Judge.
I appreciate the cooperation between the parties. Before the court proceeds further, it's appropriate to address the record. The court notes the recent filing by victim representative Erica Kirk involving the statutory right to a speedy disposition of the charges under Utah Code Section 77-38-7 sub 2. This court raises this issue solely to ensure that the record accurately reflects the statutory obligations governing the matters presently before it, and not to suggest any view regarding the merits or outcome of these proceedings. Under this statute, a crime victim has a right to a speedy disposition of charges free from unwarranted delay. When considering a defendant's request to continue a previously scheduled trial or other significant criminal proceeding, the court must inquire into the circumstances asserted as the basis for delay and must consider the victim's interests in timely resolution together with the defendant's constitutional and statutory rights. The court emphasizes that the defendant's rights to due process, to present evidence, and to receive full and impartial.
Yeah, so the thing is, you guys, I'm doing this show right here, and we're just not doing too well. And I got to go make, if I could go make a video of new information that came out in the Nancy Guthrie case, it would probably be way more beneficial for my channel. And it's just, I don't know, I'm kind of struggling with that part. I want to cover this. I can listen to it in the background, etc. But I don't know how long this is going to take.
How do you propose proceeding today?
Thank you, Your Honor. Richard Novak, again from Mr. Robinson. We're prepared to continue with Mr. Gray's testimony. We did file what I captioned a renewed request that this court proceed under a particular section of the Utah Code to refer this motion to the Attorney General. So it's obviously up to Your Honor to decide if the court wants to address that renewed request in writing now or at a different time. I do want, whenever it is
Oh, shut up, Jack.
court's view that it's timely
Get the hell
to
out of here,
address the issue that the court just brought up, which is how the court, well, what I want to address is how the court will manage the question of whether Mr. Robinson needs more time to prepare for the preliminary hearing. So the court got an update on the status of discovery. The court noted Ms. Kirk's filing, which of course we are all aware of, and we understand her rights as the representative of the victim in this case. There are challenges under Utah law when the defense needs to communicate to the court the details of its diligence in terms of preparation for a hearing, because we're not going to make a public filing of work product. And I'm sure the court understands exactly what I mean.
Yes.
So what I'm saying is the court brought up the filing and the significance of that for future proceedings. We're going to need to have, if I may, what I would call sort of a case management conference at some point about how the court will manage our need to be able to share with the court the status of our work, which we believe is confidential and privileged, in light of the fact that every time we file something and ask the court to designate it as private, we have counsel for the media trying to unseal it. And we also don't intend to disclose to the state the status of our diligence. And so I'm not asking the court to address it now. I guess I'm just trying to put a Post-it note on somebody's list. It's certainly on our list. And we didn't really intend to bring that up at the outset of today's proceeding. But since the court mentioned Ms. Kirk's filing, it just seems like the right time to mention that. So we're prepared to proceed with further testimony from Mr. Gray and keep going with the evidentiary hearing unless the court wants to address what I captioned our renewed request.
Thank you, Mr. Novak.
Thank you.
To the state.
And Your Honor, the state's prepared to go forward with the evidentiary hearing. We are prepared also to address this renewed request. If Your Honor would like to do that at the outset, I would suggest that Your Honor set a time limit on that argument so that if, assuming that that motion's denied, that we can move on with the evidentiary hearing. We've got witnesses who've been subpoenaed. They're ready to testify.
All right. Well, I appreciate that update, and I do want to give some guidance of how today's hearing is going to go, and both parties have touched upon that. Based on the record before the court as it relates to the evidentiary hearing, and in order to ensure a fair, orderly, and efficient proceeding, the court will proceed as follows. First, we will address what Mr. Novak just brought up in regards to the referral to the Attorney General's office briefly, and you'll see why I say briefly with my next statement. Counsel will have until 4:30 to present evidence, including cross-examination and any redirect. Motions for supplemental briefing are denied at this time, as the court finds the issues adequately framed for today's proceedings. These parameters are not intended to limit any party's substantive rights, but to keep the proceedings focused and free from any unnecessary delay. Upon the close of the evidence, the court will proceed to argument. Each side will be allotted 15 minutes. Mr. Novak, or to any of the attorneys who would be making closing arguments, if you intend to reserve time for rebuttal, please allocate your time accordingly. This court will conclude at 5 o'clock. And in addition, the court anticipates issuing its ruling via WebEx in order to give the evidence and the arguments presented today the careful and deliberate consideration they warrant. That proceeding will be scheduled at the conclusion of today's hearing. And so, counsel, with that in mind, we will turn to the motion to refer, or the motion concerning the Attorney General's office. I will hear from both parties. It is your time. I am not putting constraints on who you call, what questions you ask, in part, but keep in mind these time constraints as we address this issue. Mr. Novak.
Thank you, Your Honor. We filed what we captioned the renewed request because obviously at the last hearing, we brought the
Yeah, so apparently TMZ, after the press conference today in the Nancy Guthrie case, where the sheriff said that when asked, has there been a ransom note? And he goes, we take all tips seriously. We look into all tips. And it's like, that's not really an answer. So it seems like, I mean, it's weird because it almost feels like they got a tip. And then right after the press conference, TMZ came out and said that they received a, I mean, not a tip, but that they had received a ransom note. And then TMZ came out and said that they received a ransom note, a detailed ransom note after that press conference today. So is that somebody just trying to capitalize on it? Is it TMZ having somebody send them one? Because it gives them this. Why would they send it to TMZ, for God's sakes? Why not? Wouldn't you send the ransom note to the family or somebody else? Why would you send it to TMZ? What are the odds of that? Yeah, so it's pretty interesting.
This is well within the court's discretion. The statute actually tells the court that it needs to encourage the state to seek assistance. That seems to
Mark, could you just, you're just never funny.
be a gentle way to say
for once.
that the state is at least disqualified from litigating its own disqualification issue. And then I'm going to reserve the rest of my time for our evidentiary hearing and closing arguments.
Thank you, Mr. Novak.
Thank you.
Turning to the state, Mr. Ballard.
And we know that the sheriff has been giving out so much information in that case that you could almost write a pretty detailed ransom note.
It's like Groundhog Day. Here we are. We've got, again, we're supposed to be having an evidentiary hearing, and Mr. Gray should be on the stand, and instead we're arguing again this issue about whether this court can refer this issue to the Attorney General's office. And I guess if I were in Your Honor's position, I'd be wondering why the defense insists on raising this issue in a way that doesn't allow this court or the parties to be able to fully analyze it and brief it. The defense finally did file a written motion, but waited until Friday afternoon to file that. So as we've outlined in our alternative point in our response, I think this court would be well within its discretion to just deny that motion as untimely. But on the merits of that motion, I think as we've explained in our response, and Your Honor's indicated that you've read that, I think we've explained clearly why this statute does not apply in the way that the defense claims it does. And I'm happy to walk through the statute and the points that we've made. I don't want to belabor that. If Your Honor has any questions about the statute, I'm happy to answer those. But I think it's clear that this statute does not allow the court to replace a prosecutor. At best, what it allows is the court to recommend that the county attorney seek the help of the Attorney General's office. So I don't believe that this statute has any application. The cases that the defense has cited are irrelevant to this issue. And for those reasons, unless the court has any further questions about the state's opposition, I'd submit it.
Thank you, Mr. Ballard. Anything further from the parties before this court issues a ruling?
No, thank you.
All right. So before this court's defendant's renewed request to refer the pending motion to disqualify to the Office of the Utah Attorney General. In support of that request, the defendant relies upon Utah Code Section 17-18A-304, which provides that the Attorney General shall assist a county prosecutor only if the court finds that the prosecutor is unable to satisfactorily and adequately perform the duties of prosecution and recommends that the prosecutor seek additional legal assistance. The defendant argues that where there exists a non-frivolous basis, factual basis, suggesting a potential conflict of interest, the court should make such a finding and recommend assistance from the Attorney General. The court has carefully considered that argument and reviewed the briefings. However, the statute does not adopt the standard proposed by the defendant, nor does such a standard appear in existing case law or court rules. The statute requires specific findings regarding the prosecutor's inability to satisfactorily and adequately perform prosecutorial duties before referral is appropriate. At this stage of the proceeding, the court is not persuaded by those statutory conditions have been met. Based on the record presently before the court, there is no indication that the Utah County Attorney's Office lacks the resources, knowledge, or ability to litigate the motion to disqualify on behalf of the state. Accordingly, the court cannot make findings required under Section 17-18A-304 to justify referral to the Attorney General's office. For these reasons, and without expressing any views on ultimate merits of the motion to disqualify itself, the defendant's renewed request for referral is respectfully denied. All right, counsel, let's go ahead and proceed. Mr. Ballard.
Thank you, Your Honor. Could I just clean up one
Jesus. Just
piece
get
of the
moving.
record? Your Honor referred to the statute as 1718A, but I think it's actually been renumbered. It's 17-68-304 is the current citation.
Agreed.
Thank you. I appreciate that correction, and that is correct. I appreciate that, and to clarify the record, thank you to both parties. And so my ruling reflects that 17-68A-304. All right, counsel, are we ready to proceed with continuation of the direct examination of Mr. Gray?
Yes, except to quickly implement the exclusionary order that the court entered at the last hearing with respect to prospective witnesses.
All right, the court will take a very brief 3-minute
Jesus
break
Christ.
in order to accomplish all parties speaking with whoever needs to be spoken to and for them to be excluded, and then we will proceed. It is now 1:38. We'll come back at 1:41. Court is in brief recess.
Let's see. Nancy. Wow. That was like. I fixed some stuff in here. All right. Guess that's the pool camera. Looks like it's KUTV. All right. So anyways, if you guys are watching, can you guys please help support the channel? It's the only way to make it worth doing these streams during the day. I have the information that just came out. Let's just see. I also changed the title of the stream so that we could also talk about something else. Let's see. All right. So right here it said, this is what Lisa sent me. It says, news outlets TMZ has reportedly received a ransom note regarding the disappearance of Savannah Guthrie. TMZ, but this is the thing. TMZ received an unverified ransom note today. I mean, what an easy way just to boost your ratings. You know, oh, we got a ransom note from somebody. Amount for the return of today anchor Savannah Guthrie. Missing mother, Nancy. We have since contacted law enforcement. TMZ receives unverified ransom note about today's anchor missing mother. And they said, I was reading it in here earlier, they received it after the press conference. Oh, right here. In the accompanying video, Harvey Levin and Charles Ladabedier, whatever the hell his name is, spoke about the note that was sent to them by email. Levin stated that the message appeared to be a ransom note, that there was a request for certain amount of money. But why would they send it to TMZ? I mean, you know what I mean? Wouldn't you send it to the people? I mean, why them? I don't get it. Levin went on to say that the bottom of the email there are very specific things about Nancy, what wearing, that was mentioned already, and damage to the house. Okay, that's be interesting. That would essentially prove that whoever is behind the note is the person. Let's see, the outlet has also reported that the person behind the note demanded millions in Bitcoin and supplied a Bitcoin address for the transfer. The outlet has confirmed that the Bitcoin address is legitimate. That's sort of interesting. The note has demands as far as time constraints for the transfer of cryptocurrency with an or else attached. TMZ has contacted the sheriff's department and the emails being investigated. So when, it'd be interesting to know, did they get that just before the press conference? The alleged ransom note sent to TMZ was received, okay, so here it is, shortly after Pima County Sheriff Nanos held a press conference in Arizona on Tuesday, February 3rd. Nanos was asked about a ransom note during the presser, but would only say that any and all tips and leads were being properly vetted by authorities. So that's interesting. See, to me, that made me think that they had received a ransom note already.
Gray, you were last testifying in this matter on January 16th.
I heard my
right?
name. I was like, what?
And when you were
Gray.
testifying,
Oh my God.
one of the things you said
That freaked me out.
was that your office did not get involved in law enforcement decisions about which potential witnesses to interview and not interview. Do you recall testifying about that?
I said that
He goes,
our
"Gray?"
role
Yes.
as prosecutors in Utah, I realize the U.S. Attorney's Office, they actually direct investigations. We don't direct those investigations.
Okay. And so I was asking about that in the context of whether or not the adult child of one of your prosecutors
Thanks, Harley.
had been interviewed or not interviewed at the direction of your office, right?
Yes, I think I understand what you're saying.
Okay. So subsequent to the hearing on January 16th, that adult child was interviewed by SBI, correct?
Not to my knowledge.
Okay. As you sit here today, you have no knowledge whether that adult child sat for an interview on January 21st with the State Bureau of Investigation at a highway patrol facility in Orem?
I'm not aware of that.
And so then you haven't seen the reports generated from that interview?
No,
You haven't listened to the audio recording of that interview?
no,
Nobody told you that that interview was going to happen?
no. Not that I can remember. That's completely,
Okay, well, I'll represent to you that it was 5 days after the hearing on January 21st. Does that refresh your recollection at all?
oh, are you talking about after the hearing? I'm aware of that, yes.
Okay, and
Yes.
how did that come to be? Because you testified that your office has no involvement in the investigation.
Well, it was a point that you had pointed out, and so out of an abundance of caution, I believe it was Mr. McBride that decided to go ahead and do that.
Okay, and have the adult child be interviewed.
Yes,
So it's your understanding that Mr. McBride
I'm gonna
advised
go do
SBI
something.
to
I'm
do
gonna
that
go.
interview?
I gotta go. Do
that's
something.
my understanding.
Understood. Okay. You also testified on January 16th that you weren't really sure whether your office had a written policy for how to deal with either actual conflicts of interest or the appearance of conflicts of interest.
Yeah, I assume that they did, but I couldn't point to one at that time.
Okay. And then after the hearing, did you locate a written policy?
I did.
Okay. And at the time that you were discussing with the prosecutor whose adult child we're talking about, the fact that that child had been at UVU on September 10th and had witnessed many of the events surrounding Mr. Kirk's death. Did you actually consult that written policy back in October?
No, but I followed it.
Had you previously read it?
I'm sure I had at some point. I mean, it's a pretty standard policy. If there's a conflict within the office, then, or a potential conflict, then the attorney will notify us, we'll review it and decide whether any action is needed, if at all.
Okay, but when
And
I'm
that's
sorry.
what we did.
When I asked you on January 16th, is there a written policy? Your answer was, I'm not sure.
Right.
There was a subpoena for documents that you received and complied with over the last week or so, correct?
Yes.
Okay. And one of the things that we asked for in that subpoena was any memoranda or writings that memorialized how your office handled the potential conflict of interest.
As I understood the subpoena, it's any discussions regarding whether or not there is a conflict.
Right.
And so, yeah.
And so what I take from the return on the subpoena, if I could call it that, is that there isn't any memo to the file. There's no legal analysis. There's no memorialization of the decision that you made that there's neither an actual conflict or an appearance of a conflict.
No, there's not.
You mentioned when you were testifying at the last hearing that you are the president-elect of SWAP. Could you just remind the court what SWAP is?
SWAP is a statewide association of public prosecutors or public attorneys and prosecutors. It's basically a lobbying group with respect to legislative matters that affect prosecution.
And how long have you been a member of SWAP?
For about
As long as you can remember?
the 3 years that I've been county attorney, I've been a member, a board member of SWAP.
Okay. And are you familiar with a document that they produced called Utah Prosecutors Best Practices?
I know that they have that document, yes.
Did you consult that document with respect to what your office should do in connection with the potential conflict of interest or the appearance of a conflict of interest that we're discussing?
I don't believe I consulted it. I relied on my 25 years of knowledge of conflicts and so forth.
Your Honor, what I would like to do, if I may, is approach Mr. Gray with a document that I'm just going to mark for identification as Exhibit I, and that's because we've previously marked for identification A through H, if I have my alphabet correct.
Yes.
And if I may pass one up to the court, I will, if the court needs that.
No, feel free to approach Mr. Gray and present
right,
Exhibit
thank you.
I.
Gray, I'm handing you something that's been marked as Exhibit I for identification only. Oh, I'm sorry, of course. Have you seen this document before?
I've seen it, yes.
All right,
I mean, there's a lot more than just conflict in our best practices.
absolutely, but we're just
Yeah.
going to talk about that, okay?
Yeah.
All right, so what I'd like to do is turn your attention to page 2 of that document, which has a whole section addressing conflicts of interest. Would you agree with me that it starts in the middle of page 2?
Yes.
All right. And you see what I'll refer to as general standard 1.30 conflict avoidance.
Yes.
All right, could you just read that aloud for the record, please?
A prosecutor should not hold an interest or engage in activities that conflict, have a significant potential to conflict, or are likely to create a reasonable appearance of conflict with the duties and responsibilities of the prosecutor's office.
What do you take to mean a reasonable appearance of conflict?
There has to be a real actual conflict, that there could be actually an appearance of that conflict.
And that would be in the views of the public, right?
That would be based on Supreme Court case law and case law generally.
But it's an appearance. What I'm asking you is, would you agree with me that there's an appearance to the public?
Objection. This cause for a legal conclusion, Your Honor.
Witness,
Mr. Novak.
well, the witness testified that he's been aware of conflict principles for 25 years. So I think he should respond to that question.
I think this is a good argument to have with the court after the evidence has been presented, whether or not there's an appearance of a conflict, what that means. But I don't think the witness's opinion about it is evidence.
Thank you. I'm going to sustain the objection. Mr. Novak.
Understood. Mr. Gray, why don't you turn to page 3, and that would be standard toward the bottom. 1-3.3C. Do you see that?
Yes.
Okay, could you read 1-3.3C aloud for the record?
If a prosecutor believes that public perception of the integrity of the prosecutor's office and public confidence in the handling of the case would negatively be impacted by a potential or alleged conflict of interest, the prosecutor should consider recusal.
All right, Mr. Gray, I want to ask you some questions about the decision to file a notice of intent to seek the death penalty against Mr. Robinson and the fact, which is beyond dispute, that a adult child of a member of the prosecution team was present at the shooting of Mr. Kirk, all right? You state in your opposition, well, let me back up. You testified on January 16th that you are the one who drafted the opposition to the motion to disqualify, correct?
Yes.
All right. So even though there's no affidavit by you, you stand by the contents?
Yeah, I said to the extent that we could either proffer that information or testify, and here I am.
Okay. So my first question is there a formal written policy or guidelines or procedure? I don't want you to get hung up on my nouns for when your office decides to seek or not seek the death penalty in a case.
Anytime that it's an aggravated murder case, there's a potential for that.
Okay, so I understand that because that's what the statute says.
That's right.
But my question is there a policy, a procedure, a protocol, something in writing?
No.
Okay. And is it your view that it's your decision alone because you're the elected county attorney?
Yes.
Okay. And in this case, did you discuss that question, whether the state should seek the death penalty, with your team before that decision was made?
Yes.
And did that conversation include the adult prosecutor whose child is the adult student at UVU we're talking about?
No.
Are you saying that prosecutor was specifically excluded?
No, maybe I misunderstood your question.
Okay.
I thought you asked whether or not we discussed her status as a witness.
Let me back up because it was a bad question if you didn't understand it.
Okay.
Those are the rules, right? Okay.
So you discussed with your prosecution team whether or not the state would seek the death penalty against
Yes,
whoever the state accused of committing that crime.
yes.
All right. And
I should back up. I mean, I don't know that we had a discussion before they actually had an arrest. I mean, that was 2 days later, but certainly in between the time that we filed and then we did have a discussion.
okay, so what you're saying, if I'm not trying to put words in your mouth, but just so the record is clear, is that after Mr. Robinson was arrested, your team had a conversation about whether or not it would file a notice of intent to seek the death penalty.
It was rather informal. I don't know that we all got together and said, what are we going to do? I would talk to different members of my team. But I had pretty much made up my decision. And so they knew where I was going.
Did you make up your decision before there was an arrest?
I thought that based on if we had the evidence that, yeah, we would be seeking the death penalty.
And you were already aware at that time that the child of one of your team members was present at that event, right?
Sure.
All right. Now, what you're saying is that and that you discussed that with all of the team members, even if informally.
As far as the death penalty?
Yes.
Yes.
Okay. And you didn't exclude from that
No.
conversation the prosecutor whose child we're talking
No.
about. That prosecutor was included in the conversation
Yes.
about whether to seek the death penalty.
Yes.
All right. And you're aware, because I think you were present, that there were a number of press conferences held by elected state officials both before and after Mr. Robinson's arrest, correct?
Yes.
Okay. The governor, who's a former licensed attorney in Utah, held a press conference on September 10th. Were you present there?
Probably. I was president at two different press conferences.
So there was one on the 10th and one on the 11th.
I know he made other statements as well, so I'm not quite certain. I know that I was at two different press conferences.
So when Governor Cox announced at a press conference that the state was going to seek the death penalty, had you already told Governor Cox that that was your decision?
I believe his statements, the only thing that I can remember of his statements is he said, by the way, or something to that effect, Utah has the death penalty. And so that's the one statement that I'm aware of. I mean, it wasn't exactly a demand for the death penalty, but so, I mean, the death penalty, ultimately, I made my final decision by the time we filed charges, if that's.
Okay, but the question I asked you was, had you discussed with the governor your intentions?
At some point, I did. I told the governor that I intended to seek the death penalty.
And was that before Mr. Robinson was arrested?
I don't recall if it was before or after.
Okay, I'm going to represent to you, and we can file an exhibit on this in a bit, that on September 11th, the governor said at that second press conference, we are working with our attorneys, getting affidavits so we can pursue the death penalty in this case, and that will happen. And you were standing next to him when he said that, right?
I probably was.
Okay. Had you already told him that you've discussed this with your team and this is our decision?
I may have. I remember telling him that I would be seeking the death penalty.
Did you tell the governor that the child of one of the members of your office was present at the shooting?
No.
Did you tell anybody else in state government that the child of one of the members of your team was at the rally?
Not that I can recall. It just wasn't part of my thinking.
Okay. Are you aware whether the member of your team told the governor or anybody in state government about that?
I don't know. Certainly not when I was in the room with them that I can recall.
Now I'm going to ask you the same questions about federal officials. Did you inform any federal officials that one of your prosecution team members, a senior member of your office, had a child who was there at the time of the shooting?
No.
Did you tell anybody in federal government or federal law enforcement that you were going to be seeking the death penalty before Mr. Robinson was elected? I'm sorry, before Mr. Robinson was arrested?
I mean, other than, I mean, when I talked to the governor, Kash Patel and Dan Bongino were there as well. So they heard my statement that that's what I intended to do.
Okay. And were you aware that before you filed that notice, the President of the United States went on national television, said, I hope he gets the death penalty?
I had heard that he said that, yes.
That was before you filed the notice?
Yes.
All right. Now, you stated in your briefing that your decision to file the death penalty notice when you did was partly because you ran for elected office 3 years earlier on a commitment to seek the death penalty.
Yes.
So you made a commitment. Sometimes we call that a campaign promise. I'm not trying to make light of it, but that is what we frequently call commitments that we make to the voters, right?
It was a commitment that I would seek the death penalty in all appropriate cases.
And you knew before you filed the notice that the governor thought it was an appropriate case
Yeah.
and the president thought it was an appropriate case.
Yeah.
Did Mr. Patel express his views?
Not that I recall. I mean, he was doing the bidding of the president. So, but I did find it a little interesting, Governor Cox, because he plays no part in the decision. So
Did you tell Governor Cox after he made those public statements, this is not your decision, this is my decision?
no,
Was it important to you that the people you selected to be on the team for this prosecution remain on the team? I mean, you handpicked this team, right?
I did handpick this team.
All right. And the person whose child we're talking about is a longstanding, experienced senior member of your office,
Yes.
right?
Yes.
It was important for you that they be part of this case.
I want the best people on my team, and I believe I chose the best people.
May I have a moment?
Of course.
Thank you, Your Honor. We have no further questions for Mr. Gray. And if I may, what he told me is that he, after the examination, I assume that there's some cross-examination, he'll be available to be on call, so we don't need the court to address that with him, but he's going to leave the building, which is fine with us.
Yeah, but I'll be available to come back if needed.
Thank you, Mr. Gary. Thank you, Mr. Novak.
Thank you. And I'd just like the record to reflect that it's 5 minutes after 2 when I've concluded my direct.
I appreciate that.
Did you?
Not yet. Not yet.
To the state, Mr. McBride.
I'm going to refer to the prosecutor in your office whose child was present at the shooting as Prosecutor A. Do you know who I'm talking about?
Yes,
Have you ever met Prosecutor A's child that was present at that shooting?
not that I could remember. I could have in passing, but not that I can remember.
Did the presence of Prosecutor A's child have any effect on the decisions you've made in this case?
Zero.
Did that child's presence have any effect on your decision to seek the death penalty?
Zero.
Why did you choose to seek the death penalty in this case?
Because the evidence that had been gathered supports the aggravated murder charge. And I believe that the death penalty is entirely appropriate in this particular case.
On September 10th, you've testified that you learned that Prosecutor A's child was present at the shooting, correct?
Yes.
Did her presence affect the decisions you made on September 10th at all?
No.
Will you describe how her presence affected your decision-making on that day and in the few days following before you charged?
It had no effect whatsoever. I mean, quite frankly, as I think I testified earlier, I didn't even give it a second thought after I was told about that.
There's been some question about the reason you chose to seek the death penalty at the time you did. Now, the law in Utah allows you to wait to announce the decision to seek the death penalty until after arraignment, correct?
Yes.
Why did you give the notice of intent to seek the death penalty at the time you did rather than waiting?
I had learned from experience in a prior case, in particular, the Michael Jane case, that in a highly publicized case, the longer that you delay that decision, even though, I mean, I may very well make the decision early on, and I have in certain cases, but the more delay, then it just creates all this unnecessary public speculation and everything else. And we actually, in the Michael Jane case, I went to my attorneys and they said, yeah, we usually wait. But so I was waiting, but then Channel 2, I believe it was, contacted me and said that they had learned information that we were taking the death penalty off of that case. And so I had to hurry and call them before that, say that's not true. And within a month, I filed the death penalty. But it creates unnecessary angst with families of victims. I knew that this particular case was, I mean, talk about publicity. It's even more so in this case than it was in Michael Jane case. And I wanted to shut that out so that we didn't have to deal with that. And so that Erica Kirk didn't have to deal with that uncertainty.
Okay, as you made the decision in this, so that's the reason you made the decision at the time you did.
Yeah.
Right?
Yeah.
To avoid that uncertainty, speculation, and so forth.
Yes.
Was that decision made because Prosecutor A's child was present at the event?
No.
You talked about a campaign promise. When did you run for county attorney and make that campaign commitment to voters that you would seek the death penalty in appropriate cases?
It was,
What year?
it was about 4 years from this very time.
Okay.
So
At that time, did you know Prosecutor A?
I knew of him, but I mean, because I had handled,
Had you met him personally and interacted with him personally?
No,
Or
no.
you just knew who he was?
Yeah.
Okay.
I mean, at some point after I won the election, I met with him and others to determine who.
Understood. But at that time, when you were making that campaign commitment, was it because you knew Prosecutor A?
No.
Okay. Was it because Prosecutor A had an adult child?
No.
Okay. Decision making. As far as the decision making in this case goes, who makes the ultimate decisions on major decisions in this case?
I do.
Does Prosecutor A, does the buck stop with Prosecutor A?
No.
There's been some evidence that deputy county attorneys in your office went to the command center at Utah Valley University on September 10th and the days after that.
Yes.
Is that a normal process?
Yes, in any homicide case or big case, we'll have attorneys respond to the command post to offer any assistance that may be needed, which may include search warrants or discussions about, the need for certain evidence.
So having attorneys appear at Utah Valley University that day was not unusual?
How many? I mean,
No, my question is, having attorneys
yeah,
appear
no,
at the
not unusual at all.
do you know which attorneys went?
Yes, I know that I went, Mr. Grunander went, you went, Ryan McBride, and David Sturgill went. And I don't believe any others. Somebody else may have gone there for a short period of time, but I don't recall seeing them there.
Did those attorneys go there because Prosecutor A's child was present?
Not to my knowledge, no.
Aside from charging, have many major decisions, aside from charging and the notice of seeking the death penalty in this case, have many major decisions been made in this case?
I mean, major decisions. No, I mean, what comes to my mind is one major decision was to make sure that defense counsel gets discovery in a timely manner. That was quite frankly foremost on my mind once we filed the case. And I personally directed procedures to be put in place so that there would be no mistake as to what the defense counsel received and what we had. I mean, every time there's a motion, obviously the team is working on it. We work on it together. But I mean, as far as trial strategies or things like that, none of those decisions have been made.
Is it fair to say that aside from charging and the death penalty decision, is it fair to say that the most important decisions are yet to be made in this case?
Yes.
That includes trial strategy,
Yes.
preliminary hearing strategy,
Yes.
any plea negotiation.
Yes.
In all the decisions that have been made up to date, has Prosecutor A's child come up in those decisions?
No.
I should say aside from this motion.
Aside from this motion, yeah.
And so aside from this, I'm going to ask that question again to make sure the record is clear. Aside from this motion to disqualify the Utah County Attorney's Office, has Prosecutor A's child come up in any of the decisions made in this case?
No.
Has Prosecutor A's involvement in this as a witness here affected the prosecution in any way in this case, in your opinion and observation?
No.
Do you believe it will affect the prosecution in the future?
No.
Why not?
Because this is somebody that happened to be there. That has, what we're concerned about is the evidence supporting the charges. That's first and foremost. And that has nothing to do with somebody that happened to be there. Quite frankly, completely irrelevant to anything that matters in the case.
Okay. A couple other follow-ups. Earlier, you testified that Prosecutor A received a you were with Prosecutor A when Prosecutor A received a message from his child that Charlie Kirk had been shot.
Yes.
Is that right? And then you testified that Prosecutor A left to go to the scene. Do you know why Prosecutor A left? Was it to go to the scene and help law enforcement or to be with his child?
To assist in any way we can with law enforcement.
Okay. You previously testified that you did not consult the Attorney General's office about whether or not this was a conflict of interest that would require your office to leave the case or to refer the case. Why did you not consult the Attorney General's office?
Because what they would have done is, researched it and then come back, and I've done that for over 30 years in my practice, I'm capable of doing that.
Researched it where?
Case law and so forth. Again, I mean, I do not believe that there's any conflict whatsoever. I made that conclusion. I stand by that. I mean, out of an abundance of caution, we certainly notified counsel out of an abundance of caution. And I think that's the appropriate action to take. So again, I understand what the concern about conflict is whether or not it has any possibility of affecting your decision-making as a prosecutor. And I didn't see how this does in any way.
Okay, if I can have just a moment. You said you had some neighbors that had children that attended the event where Mr. Kirk was shot.
I was told that they were there. Yeah.
When did you learn that those people were there?
I don't know, a couple weeks after, I believe, after the event.
After the charging decision was made?
Yes.
How closely do you know the children that were there?
Not well at all. I mean, maybe a hello or something out on occasion. But as far as I know, I'm not even sure that they even live in our ward at all at this point.
Okay. Thank you.
All right. Mr. Novak.
No, thank you, Your Honor. I don't have any redirect at this time.
All right. And may discuss.
All right, guys. Any chance you guys can help support the channel? It allows us to keep doing these things.
Mr. Novak.
All right, we're really struggling again. So if you guys have the ability to support, that'd be
At this
great.
time, we were going to call the adult child, but I believe that individual's attorney, they're ready? Okay, then they are ready. So we would like to proceed with calling the adult child at this point. I think it would be appropriate
They
to
turn off
hear
the
whether or
channels.
not we close the hearing or at least come up with some ground rules about preventing any photography or mentioning of her name, however the court desires to handle it.
Thank you. I'll hear briefly from the parties. I did read the proffer of facts regarding the closure of portions of the evidentiary hearing on the motion to disqualify the Utah County Attorney's Office, and I'll hear any additional argument or statements prior to making a ruling.
I think they're going to close it.
Your Honor, Ryan McBride for the state. We do move to close the
Sure.
hearing for the testimony of the adult child. I think
But the judge
the
has
rationale
overruled
that I
these guys.
explained previously still stands. The rules of judicial administration allow closure for privacy and safety reasons. I believe with the proffer of facts that the
Just
defense has
audio.
accepted here, we have shown that there are privacy and safety reasons that favor closing the hearing. Defense counsel has stipulated to closure of this portion of the hearing. The media in the past has stipulated to closure of the hearing. I think the record is adequate. I think the safety concerns support closure. And absent any questions from the court, I would make that motion now.
Thank you. Anything further from the parties?
No objection, Your Honor.
All right. So the prosecution cited to the media. Did you want to weigh in?
He does not object to the closure of this portion.
Thank you.
How about just audio?
The court has reviewed the parties' prior arguments and materials submitted in advance of today's hearing, including the filing entitled Proffer of Facts regarding closure of portions of the evidentiary hearing on the motion to disqualify the Utah County Attorney's Office. The defense has requested that the testimony of certain witnesses, specifically Prosecutor A, an adult child witness, be received in a closed session pursuant to Utah Rule of Judicial Administration 4-202, citing
I'd be okay
concerns
with
related
audio.
to
I
personal
need to see your
privacy
face.
and safety. The court acknowledges that Rule 4-202 permits limited closure of court proceedings in appropriate circumstances. At the same time, this court is required to consider countervailing interests identified in Rule 4-202, including the public's right to observe the conduct of public business, to understand the operation of government, and maintain confidence in the judicial process.
He's going to rule with us.
This court must also be mindful of the
Let's see.
constitutional rights of Mr. Robinson, as well as the constitutional and statutory rights of Ms. Erica Kirk in her role as victim representative. The purpose of today's evidentiary hearing is limited and specific. The court is asked to consider the defendant's claim that a member of the prosecution team, referred to as deputy county attorney in one of the motions, has a personal conflict of interest, that any such conflict extends to the Utah County Attorney's Office, and that disqualification is therefore required. The court's role at this stage is to receive relevant evidence and to rule based on the record and applicable law without reaching the merits of those claims in advance. The parties have filed public motions outlining the anticipated evidence and testimony related to the motion to disqualify, including the state's opposition, the defense reply, and request to take evidence in the defense original motion. Those filings describe the general subject matter expected to be addressed at today's hearing. If the adult child witness is called to testify, which is the request at this point, the court will consider that testimony as part of the evidentiary record. After careful consideration of the record, the arguments of counsel, and the interests identified in Utah Rule of Judicial Administration 4-202, the court finds that closure of the adult child witness's testimony is not necessary and would not be narrowly tailored under the circumstances presented. The court further finds that the interests of openness and transparency outweigh the asserted grounds for closure as to that testimony, and that the rights of the parties and witnesses can be adequately protected through least restrictive means available to the court. For those reasons, the request of both the state and defense to conduct the adult child witness's testimony in closed session is partially denied. The court acknowledges that Utah Rule of Judicial Administration 4-202 permits limited closure of court proceedings in appropriate circumstances, and also acknowledges the concerns raised regarding the personal privacy and the safety of the adult child witness. This court's responsibility is to balance those concerns with the constitutional rights of the parties and the strong presumption in favor of open and transparent judicial proceedings.
Yeah.
Therefore, the court finds that a brief and narrowly tailored procedure is appropriate to address these competing interests. Accordingly, the courtroom will be temporarily closed, and all parties and members of the media will be excluded for the limited purpose of calling the adult child witness to the stand to state identifying information. Once that limited portion of the proceeding is complete, the courtroom will be reopened and members of the public and the media will be permitted to re-enter. During the testimony of the adult child witness, no audio or video transmission will be allowed and no photographs of the witness will be taken. At the conclusion of the adult child's witness's testimony, audio and video transmission of the hearing will resume and will continue through the remainder of the
so
proceedings.
So we just go see her there?
The court finds that this procedure is narrowly tailored,
That's ridiculous.
uses the least restrictive means available, and appropriately balances the interests of witness safety and privacy with the public's right to observe these proceedings. We will proceed accordingly. We will take a brief, we will go ahead and clear the courtroom and go into a closed session. And the only remaining parties will be the attorneys, and we will take it from that point. Court will be in brief recess for 2 minutes.
All right. I'm not sure what are you saying there. So there's no audio or video, but they're there, and we just look at a black screen, or that didn't really make any sense. But hey, guys, what's going on? We're not getting any support in here during the show. We need the support when we're doing these shows. You guys are the sole source of the income that comes into the channel. When we do these live streams, there is no ad revenue, even though you see ads that's like $4 or something. So if you have the ability to help support the channel, maybe buy some channel memberships for others, that would be great. But we haven't had any support for an hour in here, and I'm just not really sure Other channels don't care, but my channel donates. Last year we did $46,000, and that's the only way to make it happen is if people are supporting during all my shows, and I make ad revenue, etc. And I'm telling you, if I had stopped the live stream, made a quick video on the other, the Nancy Guthrie case regarding the ransom note, I would have got many subs and lots of views and would have done well. So I'm sitting here because we started it. So if you guys have the ability to help support the channel, I would appreciate it. Thank you. It sucks having to ask so many times when you guys actually know what we do. So it's frustrating for me. Let's see, what do we got here? Hey, thanks. Love true crimes and autism, my daughter's voice. And welcome. Yeah, so I can finish this part over here. The ransom note at the bottom. I mean, it didn't say what it was, but it says the note had demands as far as time constraints for the transfer of cryptocurrency with and or else. And then Nancy was last seen at her home in the. I mean, basically what they're saying. TMZ said they got a ransom note after that press conference earlier, which to me makes it seem less likely to be valid. And why would they send it to TMZ? It's probably just somebody out there, crypto crap you can't trace to who the owner is, and they're just hoping somebody sends something and then they, go off into that good night. Yeah, anyways. All right, guys, if you could please help support the channel, that would be great. We are really, really struggling. I think we're at like $25. I've been on here for an hour and 22 minutes. It's terrible. Yeah, or else she'll die, I mean, we know what the or else is. Yeah, I don't really. This whole argument is so stupid. But that's the defense is going to keep doing these little nitpicky hearings on various things just because they've got to do. They're going to throw everything they have at it just so they can say they did their due diligence, and then eventually they're going to try to plead guilty in this case. There's no way in hell. I mean, everybody. He admitted doing it. They know that. It's obvious. Apparently they said they put details in there about the damage to the house, but I mean that somebody just going by the house or reading somewhere and maybe somebody was there said what they saw and then you just write it down. That's the problem when you give out information that nobody. Man, it sucks when your request for support falls on deaf ears. It's just a really shitty feeling. Yeah, they said they gave details of what was broken. That's it. They didn't say anything in the article about what was read. All right. Yep, Tyler Robinson is the guy in the video. He is the killer. There is no doubt. That's why it's crazy to me that there's still this huge group of people that don't think he did it. And that just means our society is filled with a lot of really, really stupid people. I mean, just absolute morons. What's that? Oh, that's a picture. I'm sure what that was. Let's see. I was looking for an image. Usually it's down there. There it is. See, I always show people this one right here. See that? Look. This is the guy walking into the tunnel. That's Tyler Robinson. Look. When he was pulled over by cops. This is him when he got pulled over by cops. That's him in the tunnel. And that's him when he got pulled over by cops. That's when he got pulled over by cops. That's him in the tunnel. And there he is right there with the glasses on his forehead. And then, you know, you look at the sideburns. See that little look, that little kind of scraggly look there? That's exactly what he looks like. That's why his parents knew that that was him. Right? Pretty simple. Yeah, boy. Man. I think I'm not going to cover any more hearings until we get to the one in May. That's the that's actually like a preliminary hearing where I'm not sure what the deal is here, but I mean they're going to have a preliminary hearing where they're giving evidence and back and forth, and that'll be interesting. I just can't afford this. Let's see. Yeah. Right. Well, unless they wear a mask or something, Carol. So it's hard to say. But yeah, she might have known the person, and I mean, ransom seems like the most likely thing in that event to me.
Has really never left. So thanks to our sponsor, Visit Tucson, I got a chance to go home to show you everything from the giants of the desert where the sunsets paint.
Ah, forget it. Jeez. I don't think it is. I don't think it's closed. It's supposed to come back in 2 minutes, they said. Or I don't know. I mean, maybe there's no camera. Because he said it was kind of weird, the wording that he used, right? I thought this part was, in the interest of the public, he said he was partially, like when she said her name and stuff, but then he talked about there's no cameras, there's no audio, there's no nothing. Right? Yeah, I think there might have been other, like a ransom note already based on how the sheriff responded. There's no way you would respond like that. If you'd asked somebody, have you received a ransom note, and you hadn't received one, you'd say, no, we have not. There's no reason, there's nothing to, like, to say, I can't answer that question. That doesn't make sense to me. There's nothing you're hiding. So are they not coming back then, or? Yeah, they said they were clearing the courtroom for her to say her name, and then they bring everybody back in. Right? So they had to clear the courtroom for her to say her name and her introductory information. I think that's what they said. I'll wait another, 5 minutes, and if they don't come back, I'm going to end this live stream.
that looks, we got something in our email. So we got something in our email that looks like it's written like a ransom note for Savannah Guthrie's mother.
Specific
And they're
requests
very
for certain amounts of money,
very specific.
Bitcoin.
And also, they say at the bottom, there are certain things they're saying about what she was wearing and damage to the house.
That
as
they're
if
clearly saying to verify that
it's us.
We know what we're talking about here.
So we've contacted the sheriff's department, and we want to get them this letter. We had a little trouble getting through to the right person, but the person we spoke with is now forwarding this to somebody in the detective bureau. So if my phone rings, I may have to stop and.
What's interesting is, there was just a news conference that just ended with the sheriff, and he was asked about, and we're going to do this segment in a few minutes, but he was asked about a ransom note, and he just said, we're following all leads.
Yeah, and it's again, we don't know.
We don't know if this is legit, right.
if it's authentic or not. But they're when you read it, they're acting as if, yeah, only we would know these things, and we're serious. And there's a dollar demand and an or else in there.
Mm-hmm.
So we will let you know as this thing kind of develops.
All right, and then the Pima County Sheriff's Department said, we are aware of reports circulating about a possible ransom note regarding the investigation into Nancy Guthrie. We are taking all tips and leads very seriously. That's exactly what he said. It almost feels like they knew about that before. It was sent to TMZ and somewhere else. I bet you they didn't just send the letter to TMZ. I bet they sent it to multiple news outlets, and TMZ just got to it later than other people who were more responsible and got it and then went to the sheriff's department, or let them know, and then that's why they responded that way at the press conference, and TMZ got theirs and went, oh, ooh, let's go out, hurry up. And they already heard about it. That's why he made that statement about we're taking all tips seriously, because they had already received the same ransom note. Doesn't that make sense? Hello? Yeah, let's see. Huh? Oh, I don't know. I was just typing really fast. Yeah, people are just crazy, They get so upset. Yeah, you're right. I spelled it wrong. I was actually kind of wondering when I put that in there. Okay. But I was just typing really quick to get it out there so that people knew that we also could talk about other information. See you later. God, these people are so... People get so offended by shit like that. Yeah, this is just a troll. Every time I make any mistake at all, these people show up in the channel. But like everything that I'm covering is accurately discussed, and all these other channels put out absolute bullshit, sensationalism, and these people never challenge them on anything. It's crazy. Yeah. Sometimes when I just type really quick, sometimes I gotta do a show and I go, oh yeah, and I make mistakes, and people go, hey, great, you spelled. So you'll never be commenting again. You've wasted another one of your troll accounts. Good luck. I know you'll think you're commenting, but nobody can see it. All right? Excellent. Yeah, so I don't know. I don't think they're coming back then, right? Well, there was a ransom note sent to TMZ. Okay, I think that same ransom note was probably sent to multiple people, and that's why the sheriff has the exact same response once they heard about the note. So it's like they already knew about it. So somebody sent TMZ something. I'm sure they sent it to other people. And it was, the note had apparently stuff about the house. They wanted to sort of verify that they're legit, whatever. And I guess we'll have to wait and see. So anyways, you guys, I'm going to get going here. I'm going to take off. So thank you for being here. Thank you to KMTX, Tammy McDonald, Harley Rider, Shara Riggs, new member, and Love True Crimes gifted a membership. All right, thanks everybody. See you. Yeah, I've been doing this true crime thing for quite a while now. And during this whole time, I have not seen one person that is a crime dissector, plug rejector. I'm a certified human lie detector. Gonna get ya on a stretcher if you try and play me like an old projector. Crime sector is my nectar. Professor Gragel's gonna give another lecture. Crime collector, freak connector, and I'm always gonna be a pup protector. Fool deflector, interceptor, and I'm meaner than a specter with a vector on his pector. With all respect, y'all, just remember I've a temper fucking checked ya. I have no agenda, I'm no pretender, and I'll serve it to you straight without the blender. And in the end, I'm gonna send ya on a mission to reveal the true offender. Yeah, so I'll just get right back to work. All right, everybody, talk to you later.